Kaplack, am I saying that correct?
Yes. Yes, ma'am.
Kaplack versus Medina City School Board of Education. Before you get started too quickly, I will note that because each you have an appeal and a cross appeal, you do understand you just have the 15 minutes. So whoever goes first will have to talk about both their appeal and their argument on as a cross appellant, or cross appellate, excuse me, and then whoever goes second will have to do both things as well at that same time in rebuttal, and you can rebut however you wish to say the rebuttal time at that point in time on either argument.
Thank you.
So, then, Your Honor, is it fair to assume that both parties, whether you go first or second, will have the opportunity to reserve time for rebuttal?
No, whoever goes first will have to make their argument the first time, both on their appeal and their cross appeal. Whoever goes second will have to handle any rebuttal and make their argument at that point in time, and the last person will have a chance to rebut. I think, I suspect it's because the order they came in, we have, looked like Mr. Kaplack as the appellant and the cross appellee, so in that case, Mr. Kaplack, counsel will go first in that regard, and then the school board will go second at that point in time. So certainly understand that and make the argument that you can under the circumstances. So, attorney for Mr. Kaplack, how long would you like to reserve for rebuttal for your time? You have, of course, 15 minutes, as you know, and you may reserve up to 5 minutes for rebuttal. How long would you like to reserve?
2 minutes, Your Honor.
Okay, very good. I will be keeping time up here. You also can see it over there on the clock. Just so you know, it'll start at 15, so if you're looking at that top circle for you, when it gets to 2 minutes, that'll be the end of your initial time. Sometimes that can be a little confusing. I'll try to let you know about a minute left in your time if you're still speaking that we're getting to that point of the argument. Also, arguments are being recorded, so when you come to the podium, please introduce yourself. Make sure you speak in a clear voice so the recording can pick that up. And do try to stay behind the podium, because if you move, we might lose you. Both you visually, we'll lose you, might lose you on the recording as well. I don't think in this case it is particularly relevant, but if you knew the name of it, there were any victims or minors or anyone in this case, please you refer to them by initials or a title rather than their actual name. With that, the court has read your brief and ready to proceed.
Thank you, Your Honors. May it please the court, opposing counsel, my name is Rachel Wright. I'm the attorney that represents Coach Kaplack. This court should affirm the trial court's ruling that Coach Kaplack's termination is unsupported by substantial and credible evidence, and overturn the trial court's failure to provide for a complete remedy, including reinstatement of the coach. Reinstatement is the preferred remedy in wrongful termination cases. Coach Kaplack is a 17-year head varsity baseball coach at Medina City Schools. Relying on the referee's report, the board chose to terminate Coach Kaplack based on a partial bus video of Coach Kaplack's accountability speech after a 4-game losing streak. There were 2 adult school employees who were also present on the bus at the time of Coach Kaplack's speech, neither of whom reported anything inappropriate with the speech. The partial bus video occurred on May 10th of 2021. Following graduation, some parent players filed a complaint based on the speech. In December of 2021, the Medina City Schools evaluated Coach Kaplack. Then, just prior to the beginning of the baseball season, over 8 months after the partial bus video, the Medina City Schools terminated Coach Kaplack. The Common Pleas Court rightfully found Coach Kaplack's termination unsupported by substantial and credible evidence. However, awarded only back pay as a remedy, failing to award Coach Kaplack reinstatement to his head varsity baseball coach position. This court should affirm the trial court's ruling that Coach Kaplack's termination was unsupported by the substantial and credible evidence required, and overturn the trial court's failure to provide for reinstatement.
Do you believe the court actually reached the issue of reinstatement in its opinion?
I'm sorry, I couldn't hear you.
Do you believe the court reached the decision of whether to reinstate Coach Kaplack at all? It seemed to me there's no specific mention one way or another how they were ruling on that issue.
I would agree with you, Your Honor, that there is no specific mention of how they're ruling on the reinstatement issue. It was the order from the court was completely silent on that issue. So that is a good point.
If we were to overturn the board's appeal, would the remedy then be to remand the matter for the trial court to vote on that decision?
That's an interesting question. I think that if the court granted the board's appeal, then the court would be saying that the trial.
If we were to rule against the board, right, if we were to
Right.
grant the board decision, we would say there was no that they properly terminated him, so no issue. If we were to say we would rule against the board and say that the termination was improper, we need to remand the matter back to the trial court to make the determination whether he should or shouldn't be reinstated, since the trial court didn't make that decision in the first instance.
I don't know that you would have to do that. I think you can read the opinion as though it did, since it did not specifically state that he was reinstated, that they did not reinstate him. That's certainly how the board read the opinion, and so I don't think that the appellate court would have to remand.
Thank you.
Thank you. The case law is well established that back pay and reinstatement are the remedy for wrongful termination. In the case of Fidelli versus Finneytown Local School District, a kindergarten teacher appealed the Board of Education's decision to terminate her contract for good and just cause. The allegation in that case was that she had dragged a student 126 feet down the hallway by his arm. The board introduced 2 videos into evidence. Neither video recorded sound, nor did the videos capture the beginning of the incident. The referee in that case, similar to this case, found good and just cause to support the termination. The Board of Education adopted those findings. The Court of Common Pleas found that the board's decision was against the weight of the evidence and overruled reinstating the teacher. The Court of Appeals found that the trial court did not abuse its discretion by finding that the Board of Education's decision to terminate a teacher was not supported by substantial and credible evidence, upholding both the reinstatement of the teacher and lost wages. In Sasak versus Wellington, it was a Lorraine County Common Pleas Court that was appealed to the 9th District Court of Appeals. There was a baseball coach, Coach Sasak, who was terminated after being ejected from a baseball game for allegedly kicking some dirt onto home plate and, quote, spewing profanity at an umpire, end quote, in front of players. In Sasak, the head varsity coach filed a grievance over his non-renewal for being ejected from a baseball game. The arbitrator ordered back pay and reinstatement. Instead, the district terminated. The referee recommended the coach be reinstated with back pay. The district rejected the referee's recommendation, thereby terminating the coach. Coach Kate Sasak then appealed to the Common Pleas Court of Appeals. The Common Pleas found there was no good and just cause to terminate Coach Sasak's baseball supplemental contract. While the board draws a distinction between this case and Coach Sasak's case, I fail to see any distinction. The cases are substantially similar, and this court should rule the same. The appeal to the 9th District Court of Appeals by the board was ultimately withdrawn. The board in its briefs attempts to introduce issues that are not before the court. The board attempts to argue that the board non-renewed Coach Kaplack. The issue of non-renewal was not addressed by the referee. It was not addressed by the Board of Education. It was not addressed by the trial court, and it should not be addressed by this court.
Counsel, was pay ordered through the entire term of the contract? Did they order that he be paid for the entire term of the contract?
So they ordered 2 years of back pay.
Yes.
So it would have been the entire term of the 1-year limited contract,
Okay.
but the 1-year limited contract was never non-renewed.
Thank you.
Thank you. The Board of Education argues that this court must give due deference, that the trial court should have given due deference to the referee's findings of fact. The Board of Education must give due deference to the findings and recommendations of the referee, especially where there's an evidentiary conflict. In this case, the parties agree on nearly all the facts, including the partial plus video, which speaks for itself. The board relies on Elsis versus St. Mary's City School District to support its position. In Elsis, a teacher was found by a student and their parents while he was standing behind his vehicle, masturbating and watching a group of junior varsity girls who were standing outside of the field house. In the 33-1916 appeal of the teacher's termination, the referee found that the alleged misconduct occurred and that it met the standard to terminate. The Board of Education accepted the findings of fact and recommendations. On appeal to the Common Pleas Court, the court affirmed the district's termination of the teacher based on the referee's recommendation, finding that the teacher masturbated at a school event. This case could not be more different than the facts that are alleged in our case. In our case, there was a bus video, a speech about accountability to players who were on a 4-game losing streak. There was testimony from Coach Kaplack during the hearing where he said that it was the players that introduced the idea that there were voices in their heads from parents, from pitching coaches, from outside places, which is why there was a discussion about making sure that you filter out those voices and concentrate on the game in front of you. The board also relied on Fox versus Board of Education. It's undisputed that in that case, it was undisputed that on June 7th of 2016, the Common Pleas Court ordered the reversal of Huron's decision to terminate Fox's employment contract and reinstate the superintendent. In its decision to the Common Pleas Court, the Common Pleas Court correctly identified that there was a fair administrative hearing that was held and that there was substantial and credible evidence. In this case, the trial court held the opposite. There was not substantial and was not credible evidence to support the referee's recommendation. While deference is afforded to the referee, in Graziano, the court held that the defendant, Appalachia School Board, and the amicus curiae, Ohio School Boards Association, contend that the role of the referee under the statute is advisory, and that the Board of Education may summarily reject the recommendation made by the impartial referee, since the Board of Education is the ultimate decision maker at the administrative level. The court held that the Board of Education is not bound by the recommendation rendered by the referee, since such standard would undermine the express statutory language that provides, after consideration of the referee's report, the board, by a majority vote, may accept or reject the referee's recommendation on the termination of the teacher's contract. The clear statutory language empowers the Common Pleas Court to weigh the evidence. In Graziano, the court found that the Common Pleas Court acted well within the scope of its powers in reversing the Board of Education's decision. In Graziano, the Ohio Supreme Court held that the trial court acted within its powers and that the appellate court improperly substituted its judgment for that of the trial court.
Counsel, I still need a little clarification. Is it your position that the trial court could have ordered the board to renew the supplemental contract?
The issue of renewal was not before the trial court. So no, that
Did
issue.
you
was not
ask for that as a
decided.
remedy? Did you ask that as a contract reinstatement?
Correct.
So the issue was before the board, you asked for reinstatement.
I'm sorry.
You asked for reinstatement of the contract, and the issue was before the board.
Correct. We asked for reinstatement of the contract because when the board initiates the termination proceedings against the coach, it terminates that contract. That contract does not exist anymore. So all of the arguments that opposing counsel is making about non-renewal are not relevant because it is not, that contract does not exist to be non-renewed or not to be non-renewed because the board has taken action to sever that contract. Does that answer your question? Additionally, the district argued in its brief that it's incredibly difficult to find an example in the case literature where an impartial referee opined that termination of a teacher was appropriate. The Board of Education adopted the referee's...
The trial court seemed to give a lot of weight to the fact that there was an incomplete video of the school bus trip, for want of a better way of saying that. And I think the board pointed out, or attempted to point out, as I recall, that the full transcript, if you will, for video was not requested initially, but sometime after the board hearing. When in fact was it requested to have that full video before for evidence in this case?
So, Your Honor, the video was...
And you're down about 1 minute left of your time, just so you know.
Okay, thank you. So the video was requested immediately. It was requested immediately verbally, and that is contained within the transcript from the hearing. The board did not initiate the termination proceedings for 8 months. So despite repeated verbal requests for the video that was never produced,
So when you say immediately at the time that there was some consideration of terminating him, so 8 months later, and not immediately and then the day after the bus trip, he said, hey, can I have that same video? I assume he wasn't asking for it right away, he waited until there was some complaint about him.
That's correct, which is why there was an 8-month delay, but if you read the transcript, there were multiple verbal requests prior to the actual written request for the video, which is why there was the delay. But it was, as soon as it became clear to the coach that this was an issue, he started verbally requesting the video.
Thank you.
And I would just point out in closing that the district also argues that this conduct is hostile to the school community. The cases that the opposing counsel relies on to make that argument, I don't believe are analogous to this case, and we don't believe that this conduct was hostile to the school community. Thank you, Your Honors.
May it please the court, counsel. My name is Derek Tauster. My firm is Scott Scriven LLP, and I represent appellee/cross appellant Medina City School District Board of Education in this matter. For the sake of convenience during my arguments, I'll refer to my client as the Board of Education, which is simply the district since we have so many appeals, and Mr. Kaplack as Mr. Kaplack. I'm going to address the district appeal first, predominantly because if the district wins on its appeal, it renders Mr. Kaplack's appeal moot. So one stone, two birds here. And then I'll address Mr. Kaplack's appeal. It is the board's position that Judge Hudson of the Medina County Court of Common Pleas abused his discretion when he overturned the board's termination of Mr. Kaplack's supplemental coaching contract for good and just cause. In support of this position, the district asserts 4 positions. First, that Judge Hudson failed to accord due deference to the impartial hearing referee's findings of facts, opinion, and recommendations. Second, that Judge Hudson improperly substituted his own judgment for that of the Board of Education when he ruled that there was not substantial and credible evidence in the record. Third, when Judge Hudson ruled he erred by interpreting good and just cause without acknowledging Mr. Kaplack's behavior being hostile to the school community by disparaging parents to their children. And fourth, Judge Hudson abused his discretion by relying on facts and not on evidence, the partial video, the second half, as you will, as the predominant reason for his decision. Before we get started on the actual arguments, I think it's important for us to look at the standard of review, and for this I turned in my brief to Humphreys, which is a decision from this honorable court, where you guys very eloquently laid out the process from the board's initial termination all the way through the appellate court of review. There are 2 predominant pieces from the Humphreys decision that I'd like to emphasize for this court. First, that you all opined that the referee's findings of fact must be accepted by the Board of Education unless such findings of facts are against the greater weight or preponderance of the evidence. That's a very well-established precedent in the state of Ohio. That's why this case that we have is so incredibly rare, where the referee finds good and just cause, the Board of Education adopts that referee's findings and also finds good and just cause, and then it is appealed to a trial court who then overrules it. That just simply doesn't happen because the Board of Education was legally compelled to accept the referee's decision unless the greater weight of evidence or preponderance of the evidence was against that decision. And that's just simply not the case here. The second piece from Humphreys that I'd like to emphasize is when this court was discussing the appeal to the Common Pleas Court and that court's duty. It stated that It is well settled that the common pleas court cannot substitute a judgment for the judgment of the board where a fair administrative hearing is had and there is substantial and credible evidence in the record to support the board's decision. In the case of Barr, there is no argument that an unfair administrative hearing occurred. The only piece in Judge Hudson's opinion references that he, in his opinion, believed there was not substantial and credible evidence in the record. And I'd ask you guys to keep that in mind as we get to my second point of appeal here. The district's first assignment of error is that the trial court committed prejudicial error by failing to accord due deference to the referee. In the board's opinion, the board's position is that based on Grisano, the Ohio Supreme Court opined that due deference must be accorded to the findings and recommendations of the referee in a teacher termination case, especially where there exist evidentiary conflicts, because it is the referee who is best able to observe the demeanor of the witness and weigh their credibility. Here, Judge Hudson took the transcript wherein Mr. Kaplack talked about this partial video, and Judge Hudson took it upon himself to not give deference to the impartial referee who was assigned by the Ohio Department of Education, who sat there during the hearing and decided that Mr. Kaplack's statement that there would be some way to explain away his comments should somehow overweigh the actual video that the referee saw during the hearing.
Explain to me how we don't have the full video. Was there a late request for that? Had it been destroyed?
That's an excellent question. So first, the board contests that there wasn't a full video. I urge you, if you guys don't do anything else, I urge you to watch the video, because you will see that it is a video that starts with everyone silent on a bus, bumping along because they're riding on a bus. The bus comes to a stop, everyone stops in their seat, and then Mr. Kaplack gets up and begins his lecture. It is a full video from beginning to end. The part that Mr. Kaplack would like to try and introduce into this whole menagerie is a speech that he purportedly gave before they left the baseball diamond, 25-30 minutes beforehand, that in his opinion somehow puts his comments into context. But the district would argue, A, that there was a full video, and when Mr. Kaplack asked for his video, we gave that to him. It was only 18 months after the video was actually taken that he said to us, oh, there's another half to this that I want. And then to finally answer the rest of your question, Judge Stevenson, that remainder of the video was automatically deleted per the district's automatic retention policy. So the bus videos are on a loop and they rewrite over their memory automatically unless we pull them and save them. And since we hadn't done that.
So how long is that? So a couple points, I guess. If I understand then, the coach was asking for, I gave this speech on the baseball diamond to these kids, and then we all got on the bus and drove away. So was there been any video of the coach, the speech the coach gave on the field, if you will?
According to Mr. Kaplack, it was given, the first part of the speech was given on the bus before they left the baseball diamond.
Okay.
Then there's a 20-25 minute bus ride, and then we have the video that was actually entered into evidence where you can see Mr. Kaplack's statements. The second piece that I would, like I said, the first piece, go watch the video. It's not a partial video. The second piece that I would urge this court is even if there is a second piece to the video, it does not, there is no way to contextualize telling boys that their dads look like little girls, their dads are gossiping little children, that their parents look ridiculous and moronic, telling one student to shut up, telling students that it's sad that they have to go home and hear all this, quote, stupid stuff from their parents, telling students that he's had it with their has-been parents. He's creating a controversy between a coach who is a parental authority figure in their lives and their parents, who are one of their other adult authority figures. That is incredibly inappropriate, and it's not something that the Medina City School Board would allow its coaches to do, which is why it had good and just cause to terminate him. It's also why the impartial referee found good and just cause to terminate.
Just to clear up what the council suggested, were there verbal requests made for the tape that came in a reasonable time to get the tape from the bus? Were there not any requests at all made in time that the videotape could have been retrieved?
There were not any requests for the video at all within the time of automatic deletion. I believe, it's in the transcript that Dr. Kaplack, who's the assistant superintendent, could not tell us for sure whether it was 30 days that it starts writing over or whether it was 45 days. But nonetheless, the request came much after that window. And then again, the board's perspective, the original request was just for the video, which we provided. It wasn't until that 18 months later that Mr. Kaplack suddenly said, there's a second half to that video. And again, if you watch the video, you would never think that there's a second half. Returning to the district's first assignment of error, it's the district's position that as articulated in Graziano, Humphreys, and Elsass, which, by the way, opposing counsel tried to distinguish Elsass based on its fact pattern, I would enforce with this court that the district's citation to Elsass was not for its fact pattern, it was for its passages of law. In particular, that a trial court cannot replace its judgment for that of the finder of fact who saw and listened to the witness and had the advantage of being able to weigh the evidence. And second, Elsass stated, quote, the trial court did not have the advantage of observing the witness to determine who was telling the truth, so it could not second guess the decision of the fact finder. Those were the proponents of law coming from Elsass. It doesn't matter if he was behind a car masturbating, which, by the way, was our firm's case, so I was well aware of. Distinguishing the fact pattern has no basis when we're talking about the legal precedent established. So it's the district's position that based on Graziano, Humphreys, and Elsass, the trial court committed reversible error by failing to give proper deference to referee Gottschall's finding of fact, opinions, and recommendations, which I'll remind you the board had a legal obligation to accept. So how could it be that the trial court then gets to overrule it? Therefore, the trial court's opinion must be overturned. The board's second assignment of error is that the trial court committed prejudicial error by failing to accord due deference to the Board of Education's decision. This is slightly different from the first, right? The first, we're talking about the fact pattern. Here we're talking about administrative deference. In Fox v. Board of Education of Huron City School District, the 6th District opined that it is well settled that a common pleas court cannot substitute its judgment for the judgment of the board where a fair administrative hearing is had and there's substantial and credible evidence in the record. I told you I'd return to this point, right? We were only talking about substantial and credible evidence in Judge Hudson's opinion. I do not understand how anyone can claim that a video where you can see what is coming out of Mr. Kaplack's mouth is not credible, right? I watched him say those things. There was never an argument that the video was doctored in any way or false, so it has to be credible. So then the question is, was it substantial? And again, I won't belabor the quotes that came from the video, but the board felt like it was substantial. All 5 members unanimously felt like it was substantial. The administration felt like it was substantial to recommend termination. An impartial referee felt like it was substantial. So from the district's perspective, Judge Hudson abused his discretion by not giving deference to that Board of Education on that issue. The district's third assignment of error asserts that the trial court committed prejudicial error by failing to correctly apply the applicable legal standard. Here the district turns to Fidelity v. Finneytown Local School District from 2020, where the court cites that appellate courts have found good and just cause to include behavior that is hostile to the school community. Clearly, creating a barrier between students and their parents, or creating a conflict between students, parents, and their coach is hostile to the school community. So while Ms. Wright may argue that there are other cases where teachers are terminated for much more egregious actions, and that is certainly true, this was egregious in the way that it affects students and their parents in that home. And that is hostile.
The standard for this case is 33-1916 and good and just cause for termination?
Certainly. Yes, sir.
Turning to a question regarding Mr. Kaplack's opinion.
Of course.
Do you agree that he asked for reinstatement when he went to the board and went in for the trial court of his contract at that point in time?
I agree that their complaint, which was essentially an appeal, did ask for reinstatement, although if you look back, the district rejected that portion of the complaint in its answer because it's not appropriate for the reasons set forth in the brief. First of all, how can you reinstate a one-year limited contract that's already expired? Second of all, even if you could reinstate a one-year contract that's already expired, so let's go down this like legal fiction rabbit hole. That contract, by definition of law in 3319.11 paragraph I, specifically states from a 1989 General Assembly Action, House Bill 330, that the provisions of 3319.11I, which, if you go and read the text, states that a teacher's contract is automatically renewed if it's not non-renewed. So a board has to affirmatively go out and non-renew the action. That section of 3319.11 does not apply to supplemental limited contracts. So by operation of
You
law.
would say that for the contract for the 1 year it existed, they had standard and good and just cause. The next year for the renewal, we would look at 3319I, and that would tell us there's no automatic renewal of that, it's a limited contract.
I would argue that whether or not the board had the authority to terminate is 3319.16, good and just cause. Whether or not, if a trial court and then this court ultimately opines that Mr. Kaplack should not have been terminated, the argument of whether he gets reinstated turns on 3319.11I. And I
Did you
feel
make that argument to the trial court?
no one made that argument to the trial court because it wasn't brought up in any of the briefs by opposing counsel as to reinstatement. It was rejected in the answer and never, it was their appeal, not mine, right?
So their appeal to not raise the fact that the remedy they would like reinstatement of the contract?
In any of the briefs, correct, just in the complaint.
Okay. And you are about out of time, I see.
Thank you, yes.
Please conclude.
In conclusion, the board urges this honorable court to overturn the common pleas court decision for the abuse of discretion described, all four as I've mentioned throughout. I guess the fourth is that facts were not in evidence that he relied on, i.e. the partial video which we've talked about. The board also urges this court to deny Mr. Kaplack's appeal because his contract expired by operation of law. We didn't get to talk about it, but the board also proactively non-renew it in an abundance of caution. So no matter how you look at it, it can be reinstated.
Thank you.
Thank you.
Please the court and the council. I would also urge the court to go back and watch the video. In the district's brief, they specifically outlined some of the things that they allege were said in the video. The reference to little girls is not made in reference to the parents. It's made with the hand gesture of people talking. It's not made in reference to the parents in particular. That could be pitching coaches. That could be all of these other people that the coach was talking about in his accountability speech. The coach in the speech calls pitch calling moronic. That is what he says in the video. And when he tells the student to shut up about that stuff, it's because he is recounting how the student is in his own head, in his own mind, about all of these barriers to playing well in the game. He's saying it in a dismissive, get out of here with that stuff. You are a good player. These are the things that you should be doing. So I also encourage you to go back and watch the video. This video was a coach trying to inspire his team to do better in the next round since they were on a 4-game losing streak. This speech did not ruffle the feathers of either of the two school employees who were sitting on that bus with the coach. Additionally, while the district would like to say that this is egregious and affects parents and students in the home, there was absolutely no testimony from any players that the district put on at the hearing. There was absolutely no testimony from any of the parents. The only witness that the district put on at the administrative hearing was the assistant superintendent, who incidentally did not view these, who did not actually witness this incident and was not involved but for a second-hand investigation.
I know your rebuttal time's up, counsel.
Thank you.
The court will take the matter under advisement and will issue a decision in due course. When that decision is reached, we mail you by the clerk of court. It will also be available on the House Supreme Court's website. With that, on behalf of the court, I'd like to thank both of you for your brief in this matter and your presentations today.
Thank you.
Thank you, Your Honors.
The court is now adjourned.